Prisoners and Victims Claims Expiry and Application Dates Amendment Bill be referred to the Justice and Electoral Committee, and that the committee report finally to the House on or before 1st of June 2010, and that the committee have authority to meet at any time while the House is sitting, except during oral questions, and during any evening on a day on which there has been a sitting of the House, and on a Friday in a week in which there has been a sitting of the House, despite Standing Orders 187 and 190 subclause B and subclause C.
The question is that the motion be agreed to. Those of that opinion will say aye. Aye. Contrary, no. The ayes have it. Call Government Order of the Day number 4.
Employment Relation, Rest Breaks and Meal Breaks Amendment Bill, first reading.
Mr. Speaker.
Honourable Kate Wilkinson.
Mr. Speaker, I move that the Employment Relations, Rest Breaks and Meal Breaks Amendment Bill be now read a first time. At the appropriate time, Mr. Speaker, I intend to move that the bill be referred to the Transport and Industrial Relations Committee. Mr. Speaker, this bill has been introduced out of necessity for common sense. Statutory rest and meal breaks were added to the Employment Relations Act under the previous administration last year and came into effect on April the 1st, 2009. Nationals supported the legislation then as it gave statutory recognition of breaks, reflecting standard practice across New Zealand. This government, Mr. Speaker, still supports the intention of this law and wants to ensure all New Zealanders that their right to adequate breaks will retain statutory protection. To make it perfectly clear, all workers will remain entitled to reasonable rest and meal breaks under this bill. I expect that, as was the case with the original law, most workers will see no change to their arrangements under this bill. If the existing legislation provided sufficient legislation, this bill would not even be before the House. The fact is, the existing law has created a number of problems due to it being overly prescriptive, both in terms of what constitutes a break and the extent of flexibility about when breaks may be taken. Where professions such as sole-operated air traffic control towers had functioned quite happily for 60 years without issue, they now found themselves in breach of the law. Labor claims its amendments fixed this issue, but this is not the case. The CAA made it clear that if towers were to be closed as required under the law, they had to be shut at the same time to ensure pilots weren't forced to deal with a forever changing timetable of closures around the country. That meant New Plymouth, Napier, Gisborne, Rotorua and Invercargill would all have faced disruption to their schedules, cancelled flights and the resulting loss of revenue. But, Mr. Speaker, it is not only air traffic controllers who have been caught out by this law. Pharmacies, schools, sole charge operations such as petrol stations have all struggled to implement it. School principals have raised concerns that, if insisted upon, the current law could push hours a school has to stay open beyond 4 p.m. It's important that the law is workable and practical for every school. Other hard-working New Zealanders have also felt the impractical effects of the current law. For example, I received a letter from a mother who works part-time as a night-fill staffer for a supermarket who was unhappy with the changes. She and her colleagues have always worked 7 p.m. until 11:30 p.m. with a 15-minute paid break at 9:30 p.m. The new law has resulted in them now taking a 30-minute unpaid break at 11 p.m. and returning to the job for the final half hour, eventually knocking off at midnight. None of the staff, Mr. Speaker, wanted that 30-minute break. All they want is to do the job and go home to bed before midnight and not sit in the staff room doing nothing. It was suggested that to avoid taking the break, they cut back to 4-hour shifts, but that would mean a loss of income. Clearly, there is a practical problem here, and that is the fundamental concern with the law as it stands. Mr. Speaker, no one opposes a worker's rights to have meal and rest breaks, but dictating a general rule for every single situation does not allow enough flexibility. Instead, we are left with instances where many employers are faced with two choices: either continue as normal and break the law, or where the cost of compliance and inconvenience. Neither is an appealing option, especially when the staff and employer have their own arrangements that have long been agreeable. I have received letters from employers and employees about this, questioning why they can't just keep to their arrangements, which have worked without complaint for years. Unfortunately, the practical implications of this law simply do not match up with the intention. This bill, Mr. Speaker, is about common sense. The National Government supports all workers' rights to take breaks. That's why we voted for this legislation in 2008. But the Act needs to be fixed. Its prescriptive nature means that it is being used to cause disruption and create difficulties that did not exist before. On paper, it might have appeared sound, but practically it is flawed. Mr. Speaker, this bill will amend the Act so that it provides a requirement for employers to either allow for rest and meal breaks that give employees a reasonable opportunity for refreshment or make compensatory provision. These amendments will move the law from prescription to flexibility, encouraging employers and employees to negotiate terms that best suit their workplace. This will maintain service or production continuity and is more in line with the flexible arrangements that work so well across the country. This bill will provide flexibility so that timing of rest and meal breaks suit, as far as reasonable, service or production continuity at the workplace. The nature of breaks vary according to the nature of work, and the Act provides for employees and employers to negotiate alternative compensatory measures in lieu of breaks, such as later start or earlier finish times or accumulated time in lieu. Such arrangements are not facilitated by the current legislation. A code of practice that provides additional guidance for employers and employees to determine suitable rest and meal break arrangements will also be developed. This will help small, medium-sized businesses to identify some workable solutions on the duration and timing of breaks in different circumstances. Employers' obligations under the Health and Safety in Employment Act 1992 would continue to apply. So too the duty of good faith under the Act. This amendment, Mr. Speaker, will preserve the legislative intent to provide breaks that support employees' well-being, but will offer greater common sense and flexibility to ensure our laws support productivity in New Zealand. Mr. Speaker, I commend this bill to the House.